Hello, welcome to the newest episode of Selling Sussex, and I am joined today by Gemma Spencer, who is a local lawyer. So Gemma, welcome to the show. Thank you for joining us. Do you want to start by telling us a little bit about yourself and introducing yourself?
Absolutely. I'm a partner at Kreston Reeves, which is based in Horsham, but we have other offices in Sussex, Kent and London. We are primarily a firm of accountants and tax and wealth planners, but as you know, I'm a lawyer, so there are a few of us lawyers at Kreston Reeves, and I head up the Sussex division of the legal services. And I specialise in wills, probate and estate planning. And I work closely with our tax advisors so that we can give a more joined up approach to estate planning for our clients so that they get in-depth tax advice as well as other practical considerations. And then I typically will make a new will for them or review their will. Sometimes that ends in setting up a trust or winding up a trust or talking about gifting. Our clients just enjoy having us all under one roof. It's quite unusual to have your accountant, your lawyer and your financial planner all sitting around a table together. So it works quite well.
That's great. So obviously when my clients are looking to either buy or sell a property, is that a good time for people to come and speak to you about maybe updating their will or initially getting a will?
But not necessarily. It really depends what's in their wills. For some people, if they are lucky enough to have more than one property, they might have specifically gifted a certain property in their will to somebody or to a trust. And that could be a bit of a problem if the will doesn't make provision for a replacement property. Otherwise, the gift would fail if they don't own it anymore. But typically, people generally tend to, if they're selling a property, they're replacing that asset with something else, and it's all globally described as someone's estate. So as long as the will covers the estate, it should be okay. Although something that might be more relevant for people buying and selling is how they buy the next property, and sometimes that links back to the will, where you have couples buying a house together. You can typically buy in two different ways. It's probably a bit boring, but I'll just explain it to you because I am going somewhere with this. It's relevant. You can buy as joint tenants, which is a bit like a joint bank account where you both own the whole of it together, and if one of you dies, it automatically passes to the survivor. And that's regardless of what you have in a will. I suppose typically married couples would probably own property in that way. But you can own as beneficial tenants in common. And that's more common if you want to have different percentages in the property going to different people. So it might be if business partners or friends or colleagues or family members buy a property together, if one contributes a different amount to another, you might want to specify the ownership in those percentages. And some people forget about that when they sell and then buy a replacement, that they need to continue that pattern potentially. So I tend to just tell clients to give me a call if there are any big changes to their circumstances. And I would say buying and selling property is probably one of those big life events where it's worth getting the will out again and reading it and seeing whether it relates, because you can have trusts in wills, and they can be quite useful for couples if maybe they have a blended family, they've got children from a previous relationship. In those situations, they may want to make sure that their surviving partner or spouse is provided for, but ultimately their own estate will pass down to their own children. And trusts can be really useful for that. So if you own a share of a house, you want to make sure that it passes down to the next generation. You'd need to own as tenants in common.
So changing the topic slightly, at By Design I have a lot of clients that are looking to downsize, whether that's releasing capital, whether the property's just got too large for them, the kids have all moved out and they're just looking to move to a smaller property. Would that be a good time for a client like that to come and speak to you, maybe about estate planning or the implications of inheritance tax?
Yeah, absolutely. It can be really hard to think of ways to help people with estate planning when their estate is tied up in property, because everyone needs somewhere to live, and you might typically have somebody owning a very expensive property, but once they make the decision to downsize and free up some capital, then it opens a lot more doors to them if their estate is likely to be taxable on their death, and they are in a position to be able to give away some of their estate. Then there certainly are things we can do for them at Kreston Reeves. For some people, they might just be looking to give outright gifts to their children, but a lot of the time that's not necessarily appropriate for a number of reasons. It might be that our clients have concerns about matrimonial difficulties of their children if they aren't completely sure that all their children are settled in long-term relationships. That can be a concern, or children just aren't financially mature enough to deal with a lump sum coming into their estate. So in those cases, that's where we can start exploring trusts, which can be really useful, because the client can still retain an element of control, but get that asset outside of their estate for inheritance tax purposes, and start that 7-year clock ticking, which is the main thing that needs to be done, really.
That's great. Well, thank you so much. And you've given us tons of topics to talk about, and we could sit here all day talking about it, and it's just very much the tip of the iceberg what you can offer and what you can talk about. So all of Gemma's details and the information about Kreston Reeves can be found at the bottom of this video. And thank you so much for joining us.
Thank you.